Good evening, ladies and gentlemen. Welcome to the special town meeting of January 6, 2015. I'm town meeting moderator Eugene Cushman. And if Mr. Attorney Stevens, if you want to lead us in the pledge, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Madam Assistant Town Clerk, if you could read the call, please.
Notice is hereby given of a special town meeting to be held on Tuesday, January 6, 2015, at the East Lyme Town Hall Upper Meeting Room at 7 p.m. to consider and take action on the following. To appropriate, as approved by the Board of Finance, a special appropriation of $650,000 for settlement of litigation, a full and final release by New England National and all of its affiliates of all matters. $325,000 would come from Open Space Fund 59, $50,000 from General Fund Contingency, $146,000 from General Fund and Undesignated Fund Balance, and $129,000 from Legal Settlement Funds. Dated at East Lyme, Connecticut, the 17th day of December 2014, and this was signed by the Board of Selectmen, recorded in the Town Clerk's office, advertised in the day newspaper, and posted on the signpost.
Thank you, Assistant Town Clerk. I'm going to read the ground rules. Under Connecticut General Statute 7-6, you must be an elector of the town or 18 years of age, a U.S. citizen, and own taxable property on the grand list of 10, 1, 14, and $1,000 or more. Under Connecticut General Statute 9-360, any person that is not qualified to vote but does vote may be subject to a fine of not less than $300, no more than $500, may be in prison not less than 1 year, no more than 2 years, may be disenfranchised, or all of the above. In the event we need them, I'm going to appoint the town registrars as tellers and checkers. If you wish to speak before the meeting but you are not eligible to vote, please make that fact known to the meeting before you address the meeting. If you wish to speak, you must come up to the podium here and give your name and address for the record. Please do not conduct any dialogue amongst yourselves, but to address all questions or comments to the moderator. Now, there's only one item on the agenda, which is the item that was just read. So we will go right into that, and I will entertain a resolution to approve an appropriation by the Board of Finance of a special appropriation of $650,000 for settlement of litigation of full and final release by New England National and all affiliates of all manner. $325,000 would come from Open Space Fund 49, $50,000 from General Fund Contingency, $146,000 from General Fund Undesignated Fund Balance of $129,000 from the Legal Settlement Fund. Do I hear a resolution? Mr. Mingo, is there a second? Rita, you got it? Okay. Okay, so it's been moved and seconded, and we'll open the floor for discussion, and I'll recognize Mr. First Selectman.
Thank you, Mr. Moderator. Good evening, everyone. I'm going to give a bit of a brief history of this case, and then attorneys Block and Sicily, who have been representing the town of late, will come up and give some more detail, and then we'll all be available for any questions. On or about 1992, a company purchased the Darrow Pond property to develop a golf course. They began that process, and you may remember the Colonial Realty, I believe, collapse of 1992 or 3, caused some disasters for that company, and New England National, I believe, purchased the property sometime after that. They were, I think, going to continue the golf course, but for whatever reason, a company called Vespera purchased the property from them and was going to develop an active adult subdivision up there, an active adult development of about 664 units, complete with a little village area. The previous developer who sold that, New England National, was developing property contiguous to the Darrow's Pond, and that would be Darrow's Ridge and Kensington, and a series of easements were placed on the property designed to tie the proposal of 664 units to be developed to those roads. So there was a number of easements developed for that purpose to tie all of that together. So you actually could travel from Upper Patagonia to Route 161 down by Rocco Drive there. Those gentlemen ran into a difficult financial situation in the beginning of the Great Recession in 2007 and 8, and lost the property to the bank, and the town eventually purchased the property from the bank in a foreclosure action. We purchased the property subject to those easements, and I bring that up because that'll be brought up this evening. And in 2008, the town entered into, with the agreement of a town meeting similar to this, a compromise agreement with New England National to settle any existing claims that may have been out there, claims that stemmed from taxes from the property that was purchased in their name, and also some alleged violations by town employees. We thought that we had that settled for $250,000. There was some stipulations in the compromise agreement that both the town and the developer must have adhered to, and unfortunately the litigation continued. There were charges on both sides of failure to adhere to the terms of the compromise agreement. There was a settlement with the town's insurance company, who paid the town $175,000 and the developer actually they paid the town $275,000, and the town had to pay the first $100,000 of that to the developer. So all in all, they got $350,000 for that. The litigation has been ongoing and ongoing. It had been in bankruptcy court. Mr. Cunningham was hired at one point to represent the town. Mr. Marion before him, attorneys Block and Sicily. This goes back a long, long way. We have, since before I took office, after I was elected in the general election, up until this moment, I have spent at least a portion of almost every week of the 7 years plus on this case. You see the Board of Finance here and the Board of Selectmen sitting up here, and we thought it would be a good idea to sit to show solidarity together in favor of this settlement. You know, I have been up at this podium many times bringing many initiatives forward to all of you to ask for your support, and you've been very generous in that support. Those initiatives had to do with infrastructure improvement, bond issues, and other events. This evening I bring this to you. This is a large sum of money to settle a long-standing litigation. I believe the total cost to the town will be in excess of $1.2 million since the beginning of this, way back when. To me, it is difficult to ask the town to make this kind of settlement. But I've come to believe that it's a necessary settlement because this will end the litigation. And we can be sure of that because this has been moved out of bankruptcy court into federal district court, where the agreement has been agreed on in open federal court session by both parties, subject to your approval this evening. We ended up getting to that point through a mediation that when we could not come to terms with the attorneys and the principals, we went to mediation in Bridgeport. Members of the Board of Finance, the Board of Selectmen attended that, along with Attorney Block and everyone on the New England National side. And we went back and forth as mediation goes during most of those sessions. At first, the town thought it would be necessary to purchase or make a deal that would include the town retaining or getting ownership of all of the properties that New England National had. But we couldn't agree on a price in mediation. We finally came up with an idea that was agreeable that we bring to you this evening, that the $650,000, and I'll tell you exactly how we came up with that. There was about a 42-acre plot that has been approved for an active adult housing that's owned by New England National up on Upper Patagonia. There are a number of open lots, individual building lots in Kensington that are owned by New England National. But it was important for the town that we don't have the opportunity for further lawsuits. So we asked New England National if they would agree not to do business in town for a period of time. Part of this agreement is that they have agreed not to do business for a 20-year period. They have agreed not to develop any of those properties because we could not come to a price. The town is not a developer of land, so we couldn't come to a price on that. So what we did, and I thought it would be wise to establish a price of $250,000 to pay New England National for the rights for them not to develop for 20 years, and $250,000 to release all of those easements that are existing on Darrow's Pond and the last piece of property on the lake, the 8 acres that we don't own. We went back and forth. They came back with a larger number. We settled on this $650,000 that we bring to you this evening. And that's exactly how we came to this number. So, as I said, Attorneys Block and Sicily are prepared to talk about the details. You've heard in the resolution that was read to you by the town moderator this evening that $325,000 would come from Open Space Fund 59. Open Space Fund 59 was established back when Mr. Frazier was in office, and where was a flurry of activity to purchase land in and about Oswegatchie Hills. The state put together a $2 million bond, and the town put together a $2 million bond, and that was the money that was used to purchase a lot of those properties. You may recall we used some of the state money to purchase the most recent property, the Bayruther property of approximately 44 acres that Mr. Jutilla was able to procure at the bonding committee in Hartford $100,000 of that bond to go toward that purchase. The Friends of Oswegatchie Hills would then buy the property from the town, and the money went back and forth. So there's about, Anna, $900,000 in that fund as a result of all that activity. $325,000 we're proposing comes from that. The town carries in its budget every year an operating general fund contingency. $50,000 would come from that. We are asking for an appropriation of $146,000 from the general fund undesignated fund balance. When I first started in 2007, the undesignated fund balance is measured by a percentage of its growth according to the town budget. The undesignated fund balance was a little over 5% when I started. Through the work of the department heads and the prudent fiscal management of the town over the last few years, we've grown that undesignated fund balance to a little under 8% of the general fund budget. And that's about where it stands now. It was roughly $5 million in that fund. So we're proposing that $146,000 come from the general fund undesignated fund balance. Now, you remember I talked to you about the $175,000 that we got from the insurance company. $129,000 is roughly what's left. So the $129,000 from legal settlement funds, that's what that means. We're going to empty out that $175,000. We've been using that money to pay the attorney's fees as we move forward once we made that settlement. So that would end that. And that is how we are proposing to come up with the $650,000. And as I said, as disheartening as I feel it is to stand here and ask you for that, for the town's hard-earned money, I think it's an appropriate resolution, and I think that we will be done with this process. It will end a decade-long litigation to the community, and it will give everyone tomorrow peace of mind and an agreement that we can all live by. And financially, I think we've come up with an area that wouldn't damage the town financially. So that's a general overview. More specific questions, again, if you like, Mr. Block will come up, and I also stand available for any question that you may have. Thank you.
Thank you, Mr. First Selectman. Mr. Block, you wish to be recognized?
Thank you. Good evening, Mr. Moderator, members of the town, members of the Board of Finance, members of the Board of Selectmen.
You're not an elector of the town, correct, Mr. Block?
I'm not an elector of the town. I am special counsel employed by the town, specifically in regards to the litigation with New England National and its affiliated entities.
Thank you, Mr. Block.
I just have one correction to a statement that Mr. Formica made, and that's that this litigation goes back even further than 2006 or 2007. This case goes back to around 2002. Town has been engaged with New England National and its entities for about 12 years. And while I'm in the business as an attorney of litigating matters as part of my practice, there always comes a time in a case when an opportunity arises to settle a case. That opportunity arose once in this case, and we attempted to settle that, and that was back in 2009, and that settlement just did not work out for whatever reason. So we ended up back litigating with New England National for 5 more years. And in the course of this litigation, an opportunity arose where the parties engaged in settlement discussions privately, and it appeared that the parties themselves were reasonably close to settling the case, but we needed the intervention of a federal judge as a mediator, and we were successful in getting a judge to agree to mediate very quickly, and the parties met at the United States District Court, and we managed to piece together and cobble together what we think is a settlement that will put this litigation to an end and allow the town to go on with the town's business and allow New England National to operate outside in essence, the jurisdiction of the town of East Lyme, at least as a developer if it chooses to develop in the future. What I would like to do is just succinctly outline the terms of this settlement, and Mr. Formica gave you the background of the issues with New England National and its affiliates, and he gave you an overview of the settlement. Specifically, this agreement with New England National and all of its affiliates provide for $650,000 to be paid by the town of East Lyme in full and final settlement of all the claims of New England National and its affiliates against the town of East Lyme. New England National will convey to the town of East Lyme approximately 8.3 acres it owns in Darrow's Pond, which is part of the rest of the pond that the town itself owns now. So the town will in effect own the entire Darrow's Pond property. New England National and its affiliates will release all of the easements and property rights they control as to the Darrow's Pond property. New England National and its affiliates will be permitted to retain certain properties that they presently own. These properties may be sold, but New England National and its affiliates will not be permitted to develop any of these retained properties or apply for any land use permits, nor may they or their affiliates have any financial interest in any person or business which may purchase these properties. In other words, New England National may sell the properties to independent third parties, but may not develop these properties. This, we believe, successfully resolves the issue of the permitting of these properties, which has caused the town and New England National such problems over the years. New England National and all its related entities will execute a covenant not to develop any further real estate in the town of East Lyme for a period of 20 years. And in order to assure the enforceability of this covenant, we have the understanding of the United States District Judge Stephen Underhill that in open court he will approve of this condition, so there's no question as to its enforceability. The town and its officials will be present. New England National and all of the affiliated entities and persons will be present in court to acknowledge the enforceability of this provision and to acknowledge that all of the terms and conditions of this agreement are agreed to. In addition, Ann Torrance, who owns property on Upper Patagonic Road, will be permitted to subdivide a 3-acre parcel on which her home site sits into no more than 3 lots, provided the subdivision of this property meets existing zoning and land use regulations, and that no variances or waivers of those regulations are required. Further, the parties will exchange full and final releases, which will include release of all present and former town employees, elected and appointed officials, and other town agents. Now, specifically, I can recite to you at least a portion of that release that is proposed in the agreement. Where is it? It says, by way of clarity, the covenant in this paragraph as to retained properties is that New England National and the NEN parties are retaining their interest in the retained properties solely for the purpose of sale to independent third-party purchasers to realize any revenue from the sale of these properties. As to the release itself, it says, effective upon the execution of this agreement and payment of the settlement amount and approval of the United States District Court, the NEN parties, on their own behalf and on behalf of their principals, employees, agents, members, successors, assigns, heirs, administrators, executors, forever remise, release, acquit, satisfy, and discharge the town of East Lyme and all of its past and present selectmen, elected and appointed officials, officers, employees, insurance carriers, agents, and attorneys, and shall be deemed to have remised, released, acquitted, satisfied, and discharged from all manner of actions, causes of action, suits, debts, sums of money, accounts, bonds, bills, etc., which against the released parties, which is the town of East Lyme and all of its officers and employees, the relessor, which is New England National and its affiliates, shall or may have for, upon, and by reason of any matter or thing whatsoever, from the beginning of the world to the date of these presents, including but not limited to the compromise agreement, all claims asserted or which could have been asserted in motions, adversary proceedings, and other pleadings filed in the New England National bankruptcy case, and all facts and matters alleged or which could have been alleged in the district court complaint. We think this is as comprehensive as we can make it. It is going to be, given the approval of the United States District Court, it is going to be given the approval of the United States Bankruptcy Court, and we believe that it is a fair and reasonable settlement by the town of East Lyme, which has paid a lot of money to lawyers, has paid money to New England National, has taken innumerable hours of the selectmen, Board of Finance, First Selectmen, town staff in answering and responding to this litigation over the past 7 years or more. We don't minimize the payment that's being made, but we believe from the standpoint of all parties, including New England National, they get the opportunity to sell their properties, not do business in the town of East Lyme for at least 20 years. They can sell their property as is, where is, to whomever they want to. They just can't develop it themselves. The town makes a payment to New England National in consideration of the release and the promise not to develop in the future. So we believe the town will be able to go on and conduct its business in the future free of this litigation. And while Mr. Formica has stated that he has spent a good part of every week dealing with this case, as your counsel in this case, we have spent a good deal of time every week responding to matters. And if this settlement were not to occur, we would be spending a tremendous amount of additional time completing and concluding this litigation, which is still pending in the district court. I'm here prepared to answer questions. Attorney Sicily's here with me. She's worked with me over the last at least 4 years or 5 years on this case and has a working knowledge of areas that I may have some lack of memory as to. So much of this case is spread over so many issues. But we're happy to answer questions of anyone who has them.
Okay. Ms. Reck?
Karen Rack, 27 Black Point Road. Through you, Mr. Moderator, in 2008 compromise, what was the alleged breach by the town that New England National alleged?
Mr. Block, you want to answer that?
Subject to additions or corrections, there were a number of provisions of that compromise agreement. There was a requirement that the town issue a release a cease and desist order, which had been placed on the land records. There was a claim that the town did not release it or did not release it promptly. There was a requirement that the town obtain permits through the Army Corps of Engineers relating to the relocation of Mostoey Road.